Today in this video we are going to discuss about Civil Procedure Code 1908, in which we are going to discuss the particular topic adjournment, which is dealt under Order 17 Rule 123. தமிழிலே இதற்கு அட்ஜர்ன்மெண்ட்டுக்கு ஒத்திவைப்பு என்று பெயர். கோர்ட்டிலே வாதி பிரதிவாதி உரிமையியல் வழக்கு தொடுக்கிறார்கள். அவ்வாறு தொடுக்கும் பொழுது அதாவது இப்போ வாதி வழக்கிடுகிறார், அதற்கு பிரதிவாதி ரிட்டன் ஸ்டேட்மெண்ட் கொடுக்கிறார். கொடுத்த பிறகு ஜுடிஷியல் ப்ரொசீடிங்ஸ் நடக்கிறது, ட்ரையல் நடக்கிறது. அவ்வாறு நடக்கும் பொழுது அந்த வழக்கானது அடுத்த தேதிக்கு தள்ளி வைக்கப்படுகிறது. இவ்வாறு தள்ளி வைக்கப்படும் பொழுது மூன்று தடவை தள்ளி வைப்பதற்காக கேட்கலாம், அதற்கு மேல் தள்ளி வைக்கக்கூடாது என்பது ஒரு நியதி. ஆர்டர் 17 ரூல் 1 சொல்லுவது. அதே போல் ஆர்டர் 2 என்ன சொல்கிறது என்றால், ஒரு பார்ட்டி வரவில்லை என்றாலும் அவர் வந்தது போல தகுந்த காரணம் இல்லாத காரணத்தினால் அவருக்கு போதிய அவகாசம் கொடுத்து கூட வரவில்லை என்றால், கோர்ட்டானது அது அவர் வந்த மாதிரி ஒரு பார்ட்டி வரவில்லை என்றாலும், டிஃபெண்டட்டோ அல்லது பிளான்டிஃபோ வரவில்லை என்றாலும் அந்த வழக்கை மேற்கொண்டு விசாரிக்கலாம் என்ற ஒரு நியதி உள்ளது. அதே போல் ஆர்டர் 17 ரூல் 3 என்பது என்னவென்றால், விட்னஸ் சாட்சிகள் வரவில்லை என்றாலும், அதாவது அவர்களுக்கு போதிய அவகாசம் கொடுத்து காரணத்தை எல்லாம் கொடுத்து கூட டிஃபெண்டன்ட் விட்னஸோ ஆர் பிளான்டிஃப் விட்னஸோ வராமல் இருந்தால் அவர்கள் வந்தது போல வழக்கை நடத்தலாம் என்ற நியதி உள்ளது. அது ஆர்டர் 17 ரூல் 3 சொல்கிறது. ஸோ இதை பற்றி நாம் பார்க்க இருக்கின்றோம். ஸோ தி அட்ஜர்ன்மெண்ட் மீன்ஸ் break. It is always called break at later stated time and place. That is the adjournment, meaning of adjournment. And usually the hearing will be continuously going on without any break, or by giving break, but the adjournment should not be more than 3 times. And so hearing of suit continued till unavoidable, till the final disposal of suit. So until the final disposal of suit, the hearing be continuously going on. So that is the meaning. So it is a general rule, the hearing of evidence shall continue, and adjournment for, so usually the adjournment will be there. That is for unavoidable reason. It is wantonly the adjournment is not being done. Only for unavoidable reason it can be adjourned. The hearing can be adjourned. The court proceedings may be adjourned. But it is the discretion of the court, and it is purely to be ordered by the judge of the court. That is the main thing. That is the general rule. So the discretion of the court is very, very important. A party to the suit may ask for adjournment, but to grant or grant the adjournment or refusal of the adjournment left to the discretion of the court. So limiting, but however the limiting the adjournment is not unconstitutional. So the adjournment can be limited. We cannot say that it is unconstitutional. It is also constitutional within the limit of the Constitutional Act. When adjournment may be granted, what are the grounds for adjournment? So there should be some grounds for adjournment. They are the sickness of a party, either the plaintiff or defendant may underwent sickness. So during that time he cannot attend the court. So by showing that reason, the adjournment can be obtained from the court. Sickness of the party or sickness of the counsel, that is advocate or law officer, or the sickness of the witness, when the witness should not be depose evidence in the court for because of sickness, he cannot depose witness. For these three reasons, the adjournment can be granted. And sometimes the summons might not have been served. So for non-service of summon also, the adjournment can be sought and granted. And then another thing, a reasonable time for the opposite party to prepare their case. So suppose if reasonable time is not there, and if the opposite party feels so, then he can seek the permission from the court for the adjournment. The court feels if it is genuine and reasonable, justifiable, then the court can give adjournment. Then when adjournment may be refused, sometimes the adjournment may be refused on the following grounds. That is, the advocate could not attend on that particular day because he has to attend some other court on the particular day. So by showing that reason, the adjournment can be maybe refused. And unreasonable court of a party, advocate, sometimes unreasonable conduct of a party. So the party may have unreasonable conduct, that is, and a refusal to examine or cross-examine. Suppose if he refuses to depose the thing which is sought in examination or cross-examination, or witness present in the case, the adjournment may be refused. Then the case being very old, suppose the case is being very old, then also the adjournment can be refused. Then power of the duty of court, it is the order 17 rule 1, it is the power of the court, that is the reason the adjournment can be given, but the reason to be recorded promptly by the court, that is the reason to be recorded in writing. And then maximum adjournment not more than 3 times. Then sometimes the more than 3 times also granted, provided that should be with the proper reasons. That is with all showing proper reasons, it may be condoned by the court. Then power to extend beyond 90 days. In the case of Salem Advocate Bar Association Bar Association, Tamil Nadu versus Union of India, All India Report 2003, Supreme Court case 189. In this case, the order 8 rule 1 was evoked. That is, according to this the provision of order 8 rule 1, the defendant has to give a written statement within 90 days. Court has no power to grant or to extend beyond 90 days. Then the next one is cost of adjournment. Next one is cost of adjournment. In this, so naturally, when adjournment is asked by one party, the other party has to incur some cost, which is because of the adjournment. That cost to be borne by the party who is asking for adjournment. The cost should be commensurate with the cost of adjournment. That is, the cost of adjournment to pay higher cost to opposite party. That is, to higher cost to opposite party, that should commensurate with the cost incurred by other party. That is, the commensurate means that should be equated by the cost incurred by the other party. Because of the adjournment only, the other party incurs expenditure. So that should be to make the good the loss, the other party should burn the loss. That is the adjournment cost. Then for which the case study is Manohar Singh versus R.S. Sharma, All India Report 2010. This is cost occasioned by adjournment. This it has been decided by the case, the cost occasioned by adjournment. And the next final one is failure to appear by party, that is order 17 rule 2. In this, if the party fails to appear, then the proceedings will be going on as per the discretion of the court, and that is binding. That is the to appear, failure to appear by party, order 17 rule 2. Similarly, order 17 rule 3 states failure to appear by witness. Suppose if the witness has failed to appear to the court to depose his witness, then the court will proceed the case as if he has attended. That will not be taken as the impediment for the proceeding of the court. Then the conditions for the failure to appear by the witness, one is must have granted at the instance of a party. So the failure to appear must have been granted at the instance of a party. And to produce evidence, the other thing, to produce evidence, the next thing, act necessary for the progress of suit. These are all failure to order 17, the conditions for the failure to appear by witness. On these conditions, the witness can be fail to witness the court. So three conditions are there: must have granted at the instance of a party, and then to produce evidence, and act necessary for the progress of the suit. These three things are necessary under order 17 rule 3. With this, we conclude the adjournment. Adjournment means that is the progress of the proceedings of the court is slated for another day. That is the later stated time and place. That is the adjournment. With this, we conclude this video.